That's very interesting, you know, because you see, we are supposed to function by law. Anything less than that is disaster and aberration. This constitutional dispensation, we should look at it from the perspective of supremacy of law, not the pleasures of men and how they feel. So, if something is supposed to be done by the president, by operation of law, you should look at the law, the parameters of the law, and act upon it. Because you can't have a president acting unconstitutional and be comfortable. And so is everybody in the situation, the speaker and even the judiciary. So that's how I see what is unfolding. And I find it very, very, very interesting and how we need to uphold the Constitution and the supremacy of law for our own peace. If not, it could be very, very chaotic. That's how the little response I'll say to this.
We all clamor for speedy disposal of suits. And we say even our system does not encourage investment because suits takes forever.
Yes.
And people have heard me refer many times to this small family land matter that took 40 odd years to determine. And in 2014, when the Supreme Court eventually finished that case, Chief Justice Wood described it as a parody of justice.
Precisely.
But will it be fair in the circumstances we find ourselves where one party says, I want the case to be dealt with quickly. And you are sending notice to the one who actually brought the matter. And you are calling them today to come tomorrow. Shouldn't you give them a bit of time?
Well, they should be given time if and only if, with the greatest of respect, they've not placed before them their documents. That is all I want to say. You see, let's respect the new dispensation. The new dispensation, with the greatest respect, is not the case that the presence of a human being before a court of law will improve the documents duly filed and the law.
Sometimes substantially it does.
Well, if and only if there's necessity for the judges to say that, Samson, with the greatest respect, can you address us on this point?
That's right.
But they can dispense with all that, and it's just the paper arguments they'll look at and deal with it. So this is what I'm seeing, because in those days that we didn't have this new dispensation, you need to be physically present and move a motion and argue and urge upon the court all the authorities you believe should make you win your case.
And we are told Peter Ajete stood on his feet for 2 days.
Yes.
Arguing one matter.
Precisely.
And the court entertained him. Today, they'll give you 30 minutes, even if you are lucky.
If you are lucky. In fact, less. But right now, the statement of case that you stress, I want to drum it home because the general public should know. They didn't let my lawyer speak. And that is why I've been given an unfair treatment in the court. You see, they want to curtail the tendencies of lawyers speaking for so long, rather than reducing their thoughts together with the law in very simple terms called the statement of case. So if my good friend who is complaining about he being short-served, and it depends on the discretion of the judges, that look, in order to give him time, he's been short-served. Can we give him 2 days to return? I don't see how that could hurt a fly. I don't see how that could challenge the processes. And I didn't see the emergency that, if the case was not determined now, something serious will happen. So for me, in order to expand the parameters of fairness, I would say, well, the gentleman is alleging that he's been short-served. Can we give him, 2 days to come back to us? That will curtail some of these, accusations
in the courtroom. It would appear that the judges may have been angered.
Yes.
By the testimony of the bailiff.
I heard so.
Because the bailiff was asked, you were supposed to have served this party to come to court. Have you served? He said, I went to the offices of ADO and ADO legal attorneys, lawyers for Dafiamapo. When I got there, I was told that the lawyer says we shouldn't accept any service on this case.
Yes.
So he dumped it, dropped it, and left. We know now from CCTV footage with an audio that the bailiff was untruthful. But at the time, the court did not have the opportunity to know the other side.
Precisely.
So they were unhappy that a lawyer would treat a Supreme Court process like that.
Yes.
And the Attorney General actually called on the court to look at that matter as misconduct on the part of the lawyer.
Yes.
And refer the lawyer for punishment.
Yes. So if you look at it from that perspective, it was a bit emotive in not giving the judge, the lawyer, the opportunity to come. And the facts are showing that indeed it is not the fault of the lawyer. But let me tell you that if you pay regard to all the, if you like, paradigm shift that Dr. Muhammadu Bawumia wants to bring to bear in this entire country called Ghana, going digital. Yeah, you don't need a bailiff now to bring to the attention of anybody that, look, come to court. Because the system could just go via,
electronically.
Electronically. And then you have it. You can even have the processes on your phone, and the proof of service and the rest of it will be curtailed. But be that as it may, I will say one thing that the NDC should bear in mind. The presence of the lawyer will not improve upon the law by this current dispensation. They can even say that, look, nobody should come to court. Don't waste your energies. We will give them a date for the ruling. And the rules have changed.
Yeah.
So we should come to terms with that. But I am even surprised that people are not appreciating the move of the Attorney General. A most egregious error has been committed. No dispute about it. That the whole House of Parliament should be suspended by reason of the fact that they shouldn't do business. There's an injunction. It turned out that there was no injunction. Therefore, the confusion that what my good friend, Honorable Dafiamapo, had filed impinges on the House looking at the issues of the ministerial nominees who have been vetted for approval is a humongous situation.
Ministerial nominees who have been vetted for approval.
Yes.
And which category does not include those he has concerns about.
Yes.
Because those he has concerns about, he wants the court to compel the president to bring them for vetting.
Precisely.
The president is not bringing them for vetting.
Yes. So therefore, if you have a serious Attorney General, and I believe we have one, who went into the situation and advised the Speaker on the matter. I have the letter here. I don't believe we should go through all these matters. No. Now look, it is not the case that there was any injunction pending. The Speaker was trying to be law-abiding in a vacuum. There was nothing pending. And even if anything was pending, if you pay regard to what my good brother filed, I have it here, the issues are materially different if you look at his reliefs. So I don't see why anybody should fall there.
Except that his reliefs included an interlocutory injunction.
Yes.
Against the vetting of even those who do not fall in the category that he was against.
The absurdity is monstrous, to be very honest. That if the substance of your case, should invent another area which is not related to your case and frustrate it, then the mischief should be punishable. That's how I see it. You see, because you can't play games with the court. And by extension, you cannot use your technical skills, to even deceive Parliament. It's a very, very serious matter. And if the Attorney General wants to, if you like, remedy the wrongs, and he wants the case heard expeditiously, unfairness, and the rest of it you can talk about.
Okay.
But essentially, I am of the view that the new dispensation does not require the presence of a lawyer for the case to be improved.
So you say, for example, which is also correct,
Yes.
that they could simply have issued the hearing notice to them and they will appear, but they will not make any arguments.
At all.
You just appear to hear your ruling.
That's what it can be.
So why didn't they take this posture in the circumstance, but rather heard argument from Thaddeus Sorry, representing the Speaker, and also Godfrey Dame?
You see, I am of the view that it was a bit of a charged atmosphere and it was a bit emotive because they saw the dropping of the lawyer refusing to accept service as an affront to the dignity of the courts. Albeit, the evidence showed up that that was not the case. So that is what happens.
But judges must have the composure not to allow such emotions.
I agree with you 100%. The same argument I was making for my very revered speaker, that the letter emanating from the office of the president should not drive him to that position in which some of these matters occurred. So when we come to places of dignity and responsibility, we should manage our emotions well because the consequence...
Let's speak to the non-lawyer amongst us.